You have a website for your business. You may be wondering if you need terms and conditions or a privacy policy. Today, we'll be diving into the two documents, when you need them, and how you can get an appropriate one for your website. A privacy policy is not a contract. Rather, it is a disclosure of an organization's data usage policy. It goes into detail explaining how and why a business collects, stores, shares, and uses customer data like name and contact information, IP addresses, shipping information, credit card information, and any other identifying information. You should have a privacy policy if you collect information from your users, transfer data to third parties, intend users to interact with your website or app, or if you service users who are under the jurisdiction of a data privacy law. Privacy policy in many cases is required by law, such as for the European Union under their GDPR or for California under the California Consumer Privacy Act and California Online Privacy Protection Act. Additional jurisdictions also require privacy policies in certain situations, including Colorado, Virginia, and Connecticut. Often, you must comply with these laws if you service residents from the area, even if you are not located there. You may be subject to fines or penalties if you fail to comply. These fines can be very significant. Netflix was fined 4.75 million euros in the Netherlands in 2024 for failing to provide sufficient disclosure of their use of data, for example. LinkedIn was fined 310 million euros in 2024 by Ireland for collecting data when they did not have a legal basis to do so and for using data in misleading or discriminatory ways. Even small companies or private individuals have been hit for significant sums for violations of GDPR. It pays to ensure that you are sufficiently transparent about your data practices. So, how can you comply with GDPR and other requirements? You can do so by including a privacy policy, keeping it current, and ensuring that you never use data in a way that is not disclosed in your privacy policy. In your privacy policy, you must list the information your website collects, describe the reasoning for collecting this information, list how your website collects this information, discuss what the data will be used for, provide a way for users to contact you about your privacy policy, and outline how data is secured and protected. The privacy policy should be prominently displayed on your website, such as by including a link to it in the footer of your website or including it on sign-up forms. To draft your privacy policy, you have a few options. You can draft one yourself or you can hire a lawyer. If you are going to draft one yourself, you can search on Google for privacy policy templates, though you should carefully update any templates to reflect how your business actually operates with data. The privacy policy is only part of your approach to protecting yourself. You also should consider having a website terms and conditions, which is sometimes referred to as a terms of use or terms of service. Unlike a privacy policy, a terms and conditions is a contract between you and your users. It outlines users' responsibilities, including what will and will not be tolerated, and gives you a legal leg to stand on by protecting you. Terms and conditions can act to limit your liability, protect against copyright infringement, and specify who owns content between the company and users. You should include a terms and conditions for your website if users will sign up and interact with it, if your website is selling anything, if your website has a community element, if the website has guidelines, or if there is intellectual property on the website. Terms and conditions should be prominently displayed and easily accessed and understood. You should ensure that your terms and conditions are written clearly and simply so that any non-lawyer is able to understand them. If your terms and conditions are very complicated or hard to understand, it may impact how enforceable they are. Additionally, you should ensure that you present your terms and conditions to users and that they accept them. You should present your terms and conditions at some point where users will have to accept them to use your service. Examples might be including the terms and conditions as a checkbox when making an account or checking out for an online purchase. If you use a checkbox, you should ensure that users can access the terms and conditions through a link directly from where they are on the website. You can also consider including a link to your terms and conditions in the footer of your website. There may be more requirements for where you include terms and conditions, such as if you have an application on the App Store. Here are some key things to include in your terms and conditions. You should define your user's responsibilities and what you consider to be acceptable use. You should outline prohibited activities that users cannot do, such as hacking or spamming. You should outline who owns intellectual property, including images or content on your website, and whether the business or user owns any user-generated content. You should also take care to spell out several aspects relating to dispute resolution. Here's how to approach dispute resolution. To give you a legal leg to stand on, you should limit your liability in your terms and conditions. This section should include disclaimers and indemnification. You want to ensure that you are not liable for disruptions in service and that you are indemnified against any bad actors that engage in unscrupulous behavior through your website. With a thorough section, you can protect yourself from additional issues like incorrectly described products or inappropriate ads shown by an ad agency. You should consider defining governing law and jurisdiction so that you and your users are both aware of the governing laws. This will often be the jurisdiction where you are based or incorporated. You can also consider including a clause that identifies whether disputes will be resolved by arbitration, mediation, or litigation. It is important that you keep your website terms of service updated to reflect changes in your business and new laws. Additionally, please note that your privacy policy and terms of service should be two separate documents. You can write your own terms and conditions, or you can hire a lawyer to help you. You can also consider having a lawyer help you with particular sections, such as with the liability and disclaimer section, or have them review the entire document after you draft it to ensure you're protected. You can consider using templates or generators online, but if you do, you should ensure that you carefully review it and update it to ensure it reflects your practices and needs. Through a website terms of service and privacy policy, you can protect yourself from legal liability and ensure you are complying with applicable regulations. We have included in the description below some approachable articles that we referred to in the production of this video. We hope this was helpful. Thank you, and have a nice day.